Any mention?
Yes, Mr. Day.
May it please your lordship, if I beg to mention item number 45. Ms. Olivia Bang is actually indisposed this morning, and if I could be granted a short adjournment.
Item 45.
No objection, Lordship.
She is appearing for the state.
She's appearing for the state lordship, yes.
No objection, Lordship.
Yes, I want to hear Mr. Day on behalf of MS Soiban, London G, appearing for the respondents. When do you want it?
Next week, lordship.
1 week.
Least after 2 weeks.
Please, lordship.
Yes.
Obliged, lordship.
Please, Your Lordship. Lordship, I beg to mention item number 41.
Yes.
The learned senior counsel, Sir Khan, has some personal difficulties, Your Lordship. After 2 weeks, Your Lordship.
My lord, this item is just being dragged.
Lordship.
If it is to be, if they are having any inconvenience, I do not know, they could have informed us.
Lordship, since last 2 days they are
Our
missing.
lawyer comes, why don't you do it? The last
Lordship,
time also we indicated that.
Lordship, on last occasion they are not present here.
No, we
Last
could not
to-
come because of this Chakaband.
Last
It is
to-
known to each and everybody.
Lordship, since 2 days they are not here, Your Lordship.
But then make sure if you have any
Lordship.
difficulty, you should inform
Your
me.
Lordship, Your Lordship.
Let it be done in the month of September, because it is not possible on our part to
Too long,
come.
you see. This cannot be, you see. If lawyers convenient also cannot be the sole consideration for the court.
Because
Understand
after
that
2 weeks,
you
it
have
will
difficulty,
not
you
be
come from
possible.
outside, but that should not be something like that. See, whatever you pray, we'll accept it. Yes, when do you want it?
2 weeks, Your Lordship.
After 2 weeks, it will be difficult for us.
Okay, so we'll have it after 3 weeks.
3 weeks, Your Lordship. No objection.
It is up to the lordship.
After 2 weeks, you have difficulty.
Because there is already item is fixed. That is the only problem.
Okay, so we'll have it after 3 weeks. Just one prayer for me to give the petition list after 3 weeks. Yes.
Deeply.
Obliged, Your Lordship.
Your Lordship,
Yes.
I beg to mention item number 38, Your Lordship. Lordship, we have
Yes.
to file bullet points, Your Lordship. We have to file bullet points, Your Lordship.
Yes.
We need some time, Your Lordship.
Lordship, I have filed my written gist of argument. So let them file their bullet points.
Okay, yes. One prayer made on behalf of the petitioner. How much time you need?
2 weeks, Your Lordship.
2 weeks time is granted for submission of written gist of argument.
Obliged.
Yes.
May I please, Your Lordship. Lordship, I beg to mention item number 40, my lord. For the petition.
14, 1-4.
40, my lord.
40.
The hearing list.
Yes.
My lord, can you have the matter after 2 weeks, my lord?
Here the respondent is not appearing.
Lordship.
Okay, 40. One prayer made on behalf of Mr. Kehan and AG. List after 2 weeks.
2 weeks, my lord. Deeply obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 46, Your Lordship. Lordship, the conducting counsel, Mr. Piobin, is indisposed, Your Lordship. I can repeat this matter. This after 2 weeks, Your Lordship.
I have no objection.
So one prayer made on behalf of Mr. Kehan, Lord Counsel for the appeal with the appellate. List after 2 weeks.
Yes, Your Lordship. Much obliged, Your Lordship.
Deeply obliged.
Yes.
Supplementary cost list, item number 1.
May it please, Lordship.
Wait. Just let the file come. Yes.
Lordship, this petition under section 482 of the 482 of the CRPC, Lordship, and 528 of BNSS has been preferred to set aside and quash the FIR dated 15 October 2019, Lordship, and the subsequent proceedings of GR case number 52 AS of 2022 before the Limekra police station, Lordship. What had happened, Lordship, was
What is the offence?
offence was, Lordship, a four-wheeler, Lordship, a Maruti car and a two-wheeler.
Motor vehicles. Accident.
They involved in an accident, Lordship, in Limekra, Lordship. And now what has happened, subsequently, the parties have amicably settled the matter, Lordship, and a deed of settlement also has been annexed here, Lordship.
And what was the nature of injury received?
Lordship, injuries were, the person had to be hospitalized, Lordship, and the petitioner...
So there is no death.
No death, Lordship, no death. There is an amicable settlement, Lordship, and the deed of settlement also has been annexed here to Lordship. The Lordship would kindly come to page number 13 of the petition, Lordship.
A similar kind of case is disposed by this court.
Lordship.
Good morning.
Yes, Lordship.
Will issue notice?
Yes, Your Lordship, to the other respondent, Your Lordship,
Yes.
the complainant and the victim.
They are also been responded.
Yes,
Yes.
Your Lordship.
Yes, better. With the same order. Just same is Eilinger. And in PS4.
1, 2, and 3, Your Lordship.
23. Then you say the petitioner shall take steps for service of notice upon number 4 and 5 within 2 days.
Lordship.
You take steps within 2
We'll
days?
take a step in respect of petition.
Take it
Respondent
within
4
2
and
days.
5, Lordship.
List after 3 weeks. Yes.
Much obliged.
Much
Your
obliged.
Lordship. Number 3.
May it please your Lordship.
Yes.
Look, the petitioner here, my lord, was working on contractual basis since April 2011 in the office of the respondents. My lord, on 1st April, my lord, a complaint was made against the writ petitioner, and my lord, the writ petitioner on the very day was asked to go on leave until further orders by way of a WhatsApp message by the respondents. Subsequent to that, my lord, I have been on leave, my lord, and in fact, my lord, an FIR has been filed against me by one of the co-workers that, my lord, I sexually assaulted her. A case of molestation is pending before the Southern PS. And my lord, I was asked to participate in the investigation. I am duly participating in the investigation. But from 1st of April till date, my lord, I have sent 2 representations. My lord, there has been no reply whatsoever. My lord, I have not even been given any order of, whether it's a suspension or a termination or whatsoever, my lord. Nothing has been given to me in spite of 2 representations.
What is the term of your contracts? What is the
Well,
term?
my contract is on a yearly basis, my lord. For the last 14 years, my lord, I've been continuously working, my lord.
On extension basis.
On extension basis.
And when was the last extension made? And
Well,
what-
the last extension was made. We'll come to page 13. It was made on 8th August 2024, and my term is supposed to expire in the month of April itself. However, my lord,
2024, expired in 2024.
no, my lord, it was renewed in 2024 till 2025 on a yearly basis, contractual.
And when this incident took place, the alleged incident,
My lord, on the 1st of April, my lord.
so when the contract was in subsistence.
It was in subsistence at that point of time.
Yes.
Lordship, I'll obtain instructions. The only thing is that on 4/4/25, his contract expired. Now, from what I understand, essentially they're asking for specific performance of a contract, which is not permissible. It's a contract of service.
No, but
in
the
my
stigma is attached.
understanding. Nothing has been ordered. There is no order as such.
If it is termination simpliciter, we may not say.
My lord, there is
But
no termination.
Then
But
There is no termination. This is a case where this is a non-extension of his services.
No, as
Not a
of
case of
now,
termination.
Lordship will just come to page 24 once, my lord. I'll just show Lordship the communication on the basis of which I was supposed to go on leave. So WhatsApp message, my lord. I'll just read, my lord, the message. As directed by MD on the basis of the report received from such and such State Convention Center, you are hereby directed to go on leave for a few days until further orders.
can it be accepted as official communication?
No, my lord, that is what I am saying, my lord. There is nothing. I was asked to go on leave by the authority who I report to. My lord, I followed the instructions diligently. Thereafter, my lord, I wrote 2 representations. My lord, their representations have also not been.
Where is your contract?
Lordship will see. My lord, I don't have a copy of the contract. My lord, the only thing here is
It is not attached.
it is
Can
not
you,
here.
Mr. Sen, you obtain
I'll obtain instructions. my lord. And there is no interim prayer at the moment.
No, I've not made any interim. Well, my only thing is, my lord,
Petitioner
if
has not made such prayers. Why you are reminding the court?
my endeavor was, my lord, at least if my representation can be disposed of. Even though I'm a contractual employee, my lord, I have the right to
Do
be
you
fairly
need
dealt with.
order from a reed court for disposal of representation?
Well, the only thing is that, my lord, two representations
That is
have
also
been
a legal
sent.
right.
It is, my lord, it is, my lord, the reason why I'm saying this is, my lord, I have not been fairly dealt with. I'm a contractual employee, I understand my lord, my limitations. But still, my lord, if there is a complaint against me, my lord,
No, if
without...
it is, you see, if your termination is with stigma, definitely you
My
deserve
lord.
it. So that I cannot do it with the
Here, my lord, there is no
Whether you are-
termination, nothing at all.
That is what Mr. Shan will take care of.
My lord.
Just it hard, Mr. King. Just repeat the same of the first order. No private respondent. Mr. Shan will be for all the respondents.
1 to 5, all the respondents.
Then, then the counsel for the respondent will obtain necessary instruction before the next date. List of responses. 3 weeks.
Highly obliged.
4.
Milord, 4 and 5 are similarly situated. Only difference is, Milord, item 4, this petitioner has since retired. Milord, similar matters, Milord, are pending before the coordinate bench. And few matters also came up before your lordships last week. All tagged along together.
There is an order passed by coordinate bench in these matters.
This is an order passed by your lordships in similar matters, connected matters.
Okay.
Because the subject matter is the same, Milord.
So the other cases have already been
Yes,
listed
Milord.
before.
Yeah, they came.
So same order will.
Yes, same order, Milord.
We can pass the same order.
Both item 4 and 5.
Please, Lordship.
But then what about taking steps and all?
Milord,
No
all the
further notice.
respondents are
Here also the
represented.
private respondent is not there.
No, no,
Then
no,
no
no.
reply.
So the same order will do.
Yes, Milord.
Okay, just follow in this matter. This we can retain, Mr.
Yes, Milord, yes. So,
We'll pass the same order then.
yes, Milord, yes. Both
And then
matters.
This will be made returnable in 2 weeks.
Yes.
You just both the matters follow the same order. Just record the name of Mr. ASD. Okay, for the government. Yes.
Deeply.
Please, Lordship.
Daily list. Item number 1 to 35.
Lord, I'm praying for further 2 weeks' time to file my rejoinder, my lord, in this case. I have just received I filed an RTI. So I've just received this yesterday evening only, my lord. So I'm praying for
2 weeks may be
time.
too long, because there's urgency in these matters. My lord, we don't want the KHDC to be like the JHADC or GHADC, where after every 3 months they have to come for their salary before this court. That is my only submission.
And all along you were paying them, isn't it? So long they were there with you.
Yes, but soon. The difficulty is we have
The
to
future,
retain.
what would happen in the future?
Let it be 1 week, my lord.
1 week will be all right. See, there are a series of cases. We do not know. It should not be something like
but
that.
the issue is very simple, my lord. There's no disputed facts here. The issue is very simple. Whether the appointment is as per the rules. That's all.
But then
This court has to.
submission is that they have obtained some document
My lord.
by RTA, so they want to bring it on record.
Let it be a week, my lord.
Your Lordship, for item number 4, just yesterday, Your Lordship, we just received the counter affidavit. Item number 34.
Item 24.
34, my lord.
34.
I'm praying 1 to 33 and 35, my lord.
But the issue is more or less the same.
So we'll do
Will
one
be-
thing.
will
We'll
cover.
just 1, 2, 33 and 35. We just say on behalf of Mr. Al Karim, learned counsel, appearing for the petitioner. Further 1 week time is file it in 1 week. Just given and over. Is granted for filing rejoinder to the counter affidavit filed by the respondents. 1 week will give 1 week.
Yes.
Interim order passed earlier,
Well.
so continue. And then so far as item 34, what you will file rejoinder or not?
Rejoinder, Your Lordship.
Yes.
2 weeks time, Lordship.
Anyway, let them take 2 weeks, but the same.
But then see,
Yes.
what would be the use of passing things? Then you make it 2 weeks. There also make sure that we do not grant any
Everybody
pardon.
files it by that time.
If
First
it's
one
2
also.
weeks, then let it be an order also
My
that admission hearing will be taken up definitely, my lord, on the next date.
It depends on the council. We will take up definitely if something is there. But the first one also make it 2 weeks. Do it 2 weeks time. All those series of matter 2 weeks, make it 2 weeks. And in 34, you just say.
My lord, an endeavor will be made
My
to
lord.
dispose of these matters.
Just in 34, you just say, Mr. T.T. Ingle on a senior counsel, assisted by so and so, submits that affidavit of opposition has been filed in the matter. Stop. Mr. Rupme, Lord counsel for the petitioner, prays for and is granted 2 weeks time for filing rejoinder to the affidavit of opposition.
Interim order. Continue, Lordship.
Interim order passed earlier shall continue. Yes.
Much
Obliged.
36.
Lordship, this is the matter for the condonation of delay.
Yes.
So, Your Lordship, in this matter, this, I have challenged the order passed by the Special Judicial Officer on 9/12/2024.
On?
9/12/2024. So, Your Lordship, last question we argued the matter. In this case, Your Lordship, just I will make the gist of it, Your Lordship. Your Lordship, reference was made, and after this, under section 30, this matter was come to the Special Judicial Officer. But here, after that,
Lending decision.
Yes.
Yes, remind the court. You see, you know your case. Court may not always remind you.
so Your Lordship, in this matter, there is a limited portion here on my limitation matters.
So, the reference under section 30. So you are the claimant. The other
So, Your
side
Lordship,
was the
Your Lordship,
opposite party.
here one problem was there here. Your Lordship, in the 2008, prior to reference made and sent to the Special Judicial Officer, that point of time, the petitioner here, they informed to the Deputy Commissioner that the Ojinda Kharsati, he has already expired. So when the reference made, that time, it is made on the name of the Ojinda Kharsati. So what's happened? The petitioner here and his brother, they applied
When the reference was made? In 2008 you gave the
2012.
information.
In 2012. Sometime
2012. After 4 years of the information provided by you.
Yes. So, you will see subsequently, petitioner appeared before this court, and then
Appeared before which court?
Special Judicial Officer.
Yes.
Then, after that, they make the petition to implement them.
To?
To implement them as a one of the party. Implement. So, what's happened?
Implement them as?
As a party in this matter, in place of Ojinda Kharsati being a legal.
So that means the substitution.
Substitution. So, what's happened? You will see.
But then, see, a proceeding which has not been initiated, how could it be? You see how petition will be substituted.
So,
if there was any wrong reference, you should have corrected it before the authority concerned there.
So, you will see what's happened. The technically ground was taken that point of time that both the petitioner has signed in the petition and affidavits were shown by one of the applicant. So this was the.
Again, it could not follow. Just to say it again.
The petition was filed by the petitioner and his brother.
Okay.
So one of
These
the
two persons wanted to be substituted in place of the deceased person.
Yes, you will see. So after this was when the affidavit was signed by one of the petitioner and saying this had been authorized. So this was not allowed.
This was not allowed.
Not allowed. So when they came to know, immediately they applied for the certificate and then obtained the certificate, and then after that they filed the.
So the sole ground of rejection is that the affidavit was not signed
By both the parties.
By both the parties.
So
in spite of the fact there was authorization.
Yes. So you will see, and subsequently when this matter is again filed, and after this lastly when this special judicial passed the order, then the basic ground they have taken, it is part by limitation and reject my petition. So I am here before this honorable court.
Just tell us, be clear. You said that the petition was rejected because both the petitioners did not sign the affidavit. Only one of them signs. Now, is it the sole ground for which, on which this order was passed? Your application was rejected. If it is the thing, then we'll interfere with the order. We'll set it back,
So
and then tell the court to pass this thing, rehear the matter. If that is the sole ground.
This is the sole ground will be there in my main petition.
Is it correct, madam? This is the sole ground.
So you
So
will
that is-
that's
So it is not the sole ground. So that is.
it is a sole, according to the
Other
sole-
technical flaws also.
So you will see here after this order passed. So against the order of the special judicial officer, I am before this honorable court against the order. So now when I am just applying here in this matter, so when I have calculated these dates from the date of order, then I find there will be some delay. But if I consider these matters of this taking into consideration section 12 of the Limitation Act, 12.4, then it is within the time. So my now the convention delay.
Difficulty in understanding, Mr. Devnath.
So, now you will see now.
Have you have a written notes in your thing? You see.
I'll prepare the.
No, that is. Are you not thinking this will be very difficult for?
Everything.
This is very.
I'm just trying to give
take us to the order first. Where is the order? Where is the impugn order? We are dealing with this case number 7. Is it?
Yes.
Just where is
So
that order?
order is in the main petition. You will see. Page 27 on order. Main petition.
This is 7. Page?
Page 27 onward.
Yes.
So this is order was passed on 9/12/2024. We have applied for the certificate to be 10/12/24 and
This page 27.
27.
So this page 28 is the order. Page 20 is the
28
is the
onward
order.
this
So
one.
that order is under challenge here. 9/12.
Yes, yes. So here you see this I am referring 27 due to this LOC. I have applied for certificate on 10/12/2024 and this date
That is
fixed.
all right. See first. Let us see what is the order first.
So
We are
this
on the
page 28 you will see this order has been passed and main order start from page 30.
yes.
This is an application under section 114 the CBC filed by the petitioner. Application for review of the order dated.
So this is a order passing review.
Yes, yes.
So not on your miscellaneous application for imprisonment or substitution or whatever you say.
So you will see
That
when
means
my
you are not placing the facts properly, Mr. Devnath. This is a problem, you see. Now this order is passed in a review petition,
yes, yes.
and you said that you filed an application for substitution.
Yes, you will see this out of this order this review has come.
Out of
When this my petition has been rejected, then I filed a review.
just a second. Madam, can you just give us the facts without? Do not argue your case. Just give us the facts.
Yes, Lordship. Last occasion also I have submitted regarding the merger of that. Last occasion Lordship also inquired about the merger of the debt substitution order along with review. Because after reference, they filed an application, the petitioners herein, they filed an application for substitution in the case. Substitution oblique imprisonment, that is in not proper manner.
Because two different provisions. What is the question? Of yours?
Yes, Lordship. And they have not filed for substitution. There is some other provision is there in CPC for substitution of delay, abatement of the everything. Lordship also know about that. That substitution petition dismissed on 12/7/2019, Lordship. Subsequently, after 210 days, they filed a review petition. That is not in accordance with the provision of the CPC. And thereafter the review petition, the case was in pending under special judicial Nongpo Lordship. That was subsequently transferred here at Shillong. And learned court below heard both the sides. After hearing both the sides, they found that it is barred by limitation under section 3 of the Limitation Act. It totally barred. They did not file any condonation petition there. That is why they cannot go beyond that, Lordship. Thereafter, they have filed this revision petition condoning only 18 days of condonation, praying for condonation of delay. Actually, in this case, both the orders, substitution petition order dated 12/7/19, as well as that new order that is in review, they wanted to set aside in this case, Lordship. This is the matter. They cannot do because that wasn't in substitution petition's order was 12/7/19. That is after about 6 years delay. They did not mention anything.
It means the main order with
Yes,
regard to
Lordship.
substitution.
Yes, Lordship.
It was passed 6 years back.
Yes, Lordship.
And then
Review.
they filed an application according to which it was not maintainable in law.
Yes, Lordship.
And now they are seeking extension of that period just because they filed that review application.
Yes, Lordship. That is, they cannot go beyond that. And 115 revision petition, whether that order of review is perverse or it is erroneous.
Exactly, jurisdictional error.
Yes, yes. They cannot go beyond because there
That
is
is
so
okay,
many.
but then now we are on the consideration of condonation.
Yes, Lordship.
So we
Cannot
are
go beyond that.
Not entering merits of the revision.
Yes, cannot go.
Okay, but then the thing is that now Mr. Demnath, then just thank you at least. Yes, madam, just thank you. At least quote the fact.
Yes, Lordship.
Now tell us whether the petition, period of limitation can be extended. Just because you filed an application which apparently was not maintainable.
Your Lordship, here I am.
You can sit down, madam. You can take your seat.
Your Lordship, at the moment I am on this, Your Lordship, order passed by the 9/12/2024. I am telling this order here. Not this 2019. It will come in the merit of the case, Your Lordship. Whether it was
Okay, and this order was passed
on 9/12/2024.
Yes, and what is the ground on which this order was passed against you?
So, against this, my petition regarding this under section 104 of this CPC. Before this order, before the review petition. So, you will see here when I am approaching before this honorable court against this order passed by the special judicial officer. So, I found that if I consider this one from the date of order pass, then there is delay for 18 days.
Date of which order?
9/12/2024.
No, but the 9/12/2024 is basically an outcome of a petition filed by you, which apparently was not tenable in law.
So this
now, say supposing if that is the thing, then what remains is that order dated 12/7/2019.
I will come in this later on, Your Lordship.
No, we are comparing just help us in
because of
setting
it, Your
correctly
Lordship.
on which way we compute the period of limitation.
Your Lordship, in this matters, Your Lordship, that's why I got the instruction, Your Lordship. Mr. Khain is not well, so that's why I am presenting. I discussed with him, Your Lordship, the matters, and he says,
with whom?
Well, Mr. B.M. Khain was dealing, who is our senior colleague, Your Lordship says, always practice. Now he's sick. So he is having the
He has been appearing in
let us.
So, Your Lordship, just he was knowing about it, and then whatsoever petition given, I understand. So, Your Lordship, the petition filed under section 1 for the CPC, whatsoever I came to know him, it was within the limitation, and if the called records, then after this it can be satisfied. Because when he's got the knowledge about the order, and after this he applied for the certificate PV, and immediately he has filed the review petition, it is within the time according to him. What's my instruction?
So that is the legality of the correctness of the order is under challenge here.
So, Your Lordship, now I am here, Your Lordship. Why I filed the limitations? Because if I say it is within the limitation, The question is there, Your Lordship. Because of it, Your Lordship, I have applied the certificate on 10/12/2024.
No, otherwise, according to you, how many days delay is there? According to you, how many?
No delay.
No delay.
If I consider this,
Why you filed this condemnation application?
because of it, Your Lordship, from the date of considering this date of order, and when I filed this petition, if I consider it's more than 90 days. So that's why I filed this petition. And if I consider this one, section.
So, according to you, how many days delay is there?
There will be no delay, Your Lordship.
Then, in your petition doesn't say that there is a, doesn't mention anything about period of delay.
Yeah, I have mentioned, Your Lordship.
Then, we do not know. You see, you are taking contradictory stand. You say one thing is not delay, then again you say you file a condemnation application. If there is not delay, then you should have preferred the revision application directly.
Your Lordship, this paragraph 4, page 5 in my limited petition. Paragraph 4, page 5, Your Lordship.
How many days delay? What is the problem in telling it? How many days delay?
Considering all, it is 18 days.
18 days. So it is only 18 days. So if it is only 18 days, why, madam? What is the problem?
Last occasion I had submitted before this honorable court. There is a 5 years because the revision petition filed. In this petition, they have challenged both the order, 12/7/19 as well as this order.
From the prayer, my lord, it can be understood.
Yes, Lordship.
From the prayer,
No, it's okay. It's okay. See, one thing is that
now
they sought review of that.
In the guise of review, they wanted to condone the delay of 6 years, Lordship.
No, but then whether that review was maintainable or not.
That is different. It is barred by limitation, Lordship.
Do we decide in the petition of condonation?
Yes. Now, first, Lordship has to decide the condonation petition.
Yes. So that is what. So
Yes,
for
Lordship.
deciding the question of condonation, do you go to the question whether the review petition was maintainable in law or not?
That is different point.
So what
It
is the relevant point then?
18 days. It cannot be 18 days
Yes,
because they have challenged. Main petition is a revision petition. Main petition herein, against that, they have filed condonation petition, challenging both the order. If they ought to have filed on the review on the basis of review petition, but they have challenged both the order. Order dated 12/7/19 as well as 9/12/2024.
Because 12/7/19 was under challenge in that review petition. That is why. That is the reason.
No, but because that after this.
See, suppose.
Lordship,
just for
yes,
example,
Lordship,
please.
Lordship.
Say supposing
Yes,
if we find that his review petition was maintainable and it was allowed, then even that order dated in 1907 also would be modified accordingly.
That is, then it would be merged. But it is not merged because it is not decision was not taken on the merit. It is barred by limitation.
We are not bringing merger here. Just do not bring merger. What is that? Is that say supposing if his review
Yes, Lordship.
is allowed, then order dated 1907 also will accordingly stand modified, or it may be
Yes.
recalled and matter will be reheard.
Yes, but
Isn't it?
Yes, Lordship.
This is one side of the matter.
Yes, Lordship.
Leave aside your contention for the
Yes,
time.
Lordship.
We are discussing for the purpose of understanding. Now we decide whether the review petition was maintainable or not. We decide it in the revision application, isn't it? Not in the condonation application. Now, so far as your contention is concerned, what we could get it, what we can understand, that the period of limitation, in so far as the order dated in 1997 is concerned, cannot get extended just because they filed a petition which apparently was not maintainable. Now, that is what your contention is, isn't it?
No, Lordship, that was filed, the review petition was filed against that order of substitution after 210 days. That is beyond the period of limitation.
That is what?
Yes, Lordship.
So, according to you, that review petition itself was not maintainable, isn't it? Because it was barred by law.
Barred by law.
So, definitely, since the review petition was not maintainable, the period of limitation for order dated 1907 also will not extended just because the review petition was filed.
Yes.
You have any law like that? You have holding anything, any decision dealing with that kind of
It
situation.
attained in finality. That order, when the learned court below, that is review petition, on the order dated 12/7/1919, that was challenged in review, and after 210 days, that was barred by limitation. Learned court below, after going through that, dismissed the petition because of the barred by limitation. And the order passed on in the substitutory has attained in finality after dismissal of the review petition.
Can those be consideration? Can those be a consideration for determining this application of condonation? What you say
No, because they
may
have
be correct, but then that we consider at the time when we take up the revision application, not in this condonation application.
not in condonation, because condonation, they challenge both the order in the revision petition, Lordship.
See, one thing is that so far as the order passed in the review petition, whether it is right or wrong, we decided in the revision application. Right now we are dealing with condonation,
Yes.
and condonation against the order of the
912.
order passed in review application.
My lord, if my lord will see the page number 21 of the revision application, my lord.
Revision application.
Yes.
Revision.
Page number 21.
Yes.
It says to show cause as to why the impugn order dated 9/12/2024 in Miss case number so and so, and the impugn order dated 12/7/2019 passed in impleadments/substitution application number so and so by the learned reference court should not be set aside. Now here, my lord, they have challenged both the orders. One is 9/12/2024. If they would have filed revision application against the order 9/12/2024, my lord, then probably the days of limitation is 18 days. Here, my lord, they have challenged two orders, that is 12/7/2019 and 9/12/2024. So, as far as 12/7/2019 is concerned, my lord, there are almost 6 years of delays. So, even that delay has to be explained when they are challenging the order.
See, Mr. Sikon, just appreciate one fact,
my lord,
that this review petition was filed seeking review of order dated 12/7/2019.
No, my lord, both the order, my lord.
12/7 review application, not talking about this revision.
They have challenged both the orders.
But as per the petition,
Wait.
my lord,
We are not talking about the revision application here.
my lord.
The review application which was filed
Right.
before the special judicial officer,
Yes, my lord.
it was filed seeking review of order dated 12/7/2019.
Right, my lord.
Isn't it?
Right.
Now just for a moment, take it that if that review was allowed,
My lord.
in such a case, this order dated 12/7/2019 would have stood modified.
Right.
Correct?
Right, my lord.
Isn't it?
Right.
So it depends upon, now for us it depends upon whether right now it is basically up for us to see whether order passed in the review application was correct or not.
Yes.
That is what has been established.
Yes, my lord. If
So essentially we will be considering the period of delay which is occurred from the date of passing of the order in the review.
but
Except in case only you say, because according to you, review application was not at all maintainable in law.
right,
Isn't it?
right.
Now, except if you say that since this review application was not maintainable at all in law, the period of limitation for challenging the order dated 12/7/2019 cannot be extended.
That is not my questions, my lord. That is not my stand. What my contention is, my lord, if the petitioner has to challenge the order dated 12/7/2019, he has to also explain the delay for the last 6 years. Because here, if he would have just challenged only the order dated 9/12/2024, there was only 18 days delay. But here, my lord, he has challenged both the order. Therefore, even for order dated 12/7/2019, when he has challenged this order, he has to explain the
So you want
delay.
to say that a period of delay for both the orders cannot be merged.
Cannot be merged, my lord. Cannot be.
That is what you were saying.
Yes, when he is challenging both the order.
That is what we could understand you.
Yes, ma'am.
Any law in this regard?
Yes.
You have any law with you?
I need give some judgment also.
You have supplied.
No,
have you supplied?
not yet.
You have filed an objection. You
Yes,
filed
Lordship, I have filed.
and you have raised your grounds there.
Yes, Lordship.
Okay, we'll pass forward with that. In contention application. You want to supply as a judgment?
Yeah, yes, I'll.
What is the judgment about?
Lordship, I am.
You have anything?
I'm having some judgment, Your Lordship, that continuation delay can be considered.
Have you given her a list?
This I didn't give you, Lordship.
You should have supplied to the other side. That is the practice now. That whatever you want to rely, you furnish it to the other side also. At least the list.
Regarding merger also, I am giving.
You also,
note.
madam, supply a copy of what you are giving, because at least the council should have an opportunity to see what law has been cited.
2 copies, only 1 copy here.
No, you do not. At least the list. If you do not give the judgment, the whole judgment.
Huh? More episode yes. This is regarding merger.
And you just wait. Let us see what Mr. Javnath has to do.
Yes. Nomination also going to pay to Bharat, total Bharat.
My SCC was not working, which I just.
See, Mr. This Indian Kanun downloaded one will not see. There happens very many mistakes. Just give us.
Your Lordship, my SCC was not working, Your Lordship, so that's why.
So you could have given a list here.
So I can give the compilation, Your Lordship, 4 judgment is there. 2 judgment is for the continuation delay, and another 2 judgment is there. That's at the moment, merit of the case cannot be heard. Only the limitation.
Definitely, merit of the question cannot be heard, but then the factual aspect has to be taken into consideration. We are not on the merits. That
So
is all. You do not have to furnish anything on that. That
So
merit of the
Lordship,
case.
I'll give the bullet point and then this judgment together. My SCC was
So
not
what you
working.
want to refer from here? This one, this Pradeep Kumar Kalita.
This one, last paragraph 12.
It's not a Supreme Court decision. It's a Guwahati High Court.
Yes, it is got it.
What the?
Ekin pori jokta, support all problem. Etu pori jok limitation or factor. Etu kurse limitation it.
Which paragraph?
Paragraph 12, last paragraph. However, if an application made or
No,
obtained the
not
certificate to be,
paragraph 12 doesn't start with however.
it is here. This in between last 3 paragraphs, last 3 lines. In view of our discussion, and then after this, however, if an application is made, last 3 lines, paragraph 12.
Paragraph 12 is a small paragraph. You can read the small.
In 1920.
In view of our aforesaid discussion, our answer is the question posted in opening paragraph of this judgment is that the limitation for an application could be start running from the date of the judgment and not from the date of the degree. The date of the degree should be deemed to be date of the judgment. However, if an application is made for obtaining the certificate of the judgment and
That is
degree,
okay. That is well known. Their objection is not on that actually. You see, the crux of the issue is somewhere else. So far as the objection of the respondent is concerned, it is with regard to the maintainability of the review application and whether the period spent in that review can be condoned.
A to B, same.
This is something else. You are saying something else. The period obtained for obtaining period spent for obtaining certificate copy should be excluded.
so here
That
you
is-
will
that
see,
should be-
we are on against the order of the order passed by the Special Judicial Officer in 9/12/2024, We are on it at the moment.
Revision petition is filed against both the order, challenging both the orders. Against that, the review petition filed. Condonation petition filed.
You can understand, then give us some law. If two orders are challenged together, then which will compute the period of limitation?
And section 115, if the petition is under section 115 of the CPC, whether the order passed by the learned court below is perverse or it is erroneous.
That will decide in the revision application.
But that should
Not
be
in the
looked
condemnation
into.
application.
That should be looked into.
See, jurisdictional
No,
error
yes,
or
Lordship.
perversity will decide it only
Yes,
when we go to the main.
I know about it. But they have challenged both the orders. Revision petition against that, their condonation petition filed.
That is why this court is asking you, when
Yes.
two different orders passed on different dates
Yes.
are challenged before this court, then which way should compute the period of delay?
Computer, because after dismissal
Give
of,
us some law. Give us some
that
law.
is I am giving, Lordship.
Please give us and show us why you are spending time
Because
unnecessarily.
I am not spending time. He has submitting me.
Give us, if you are ready law, please.
He has submitted before this honorable court. Why, Lordship?
Citation, what citation? Citation?
एक मिनट रुको ज़्यादा लोग तक ये ले देखिए
This is Supreme today.
सुप्रीम कोर्ट टुडे कॉपी टू लास्ट पेज আপনারা লিখে নেন তো নাহলে আমি উপরে করে দিচ্ছি
This is the one you gave, one copy.
Yes. And page 16 of this.
This is second appeal, 100 section 100.
Yes.
Yes.
That is specifically mentioned about the bar of the limitation period under section 3.
Yes.
Court cannot go beyond that.
That is all right. The
That
query
is
of
why
query
the
of
order
court-
passed by the learned court below is maintainable.
Just show us the part. Show us the part. Show us the part which you want to show.
This relevant for quotation. Para 2021.
Just read it.
Please.
Just tell the court.
2021.
I'll just read out, my lord. She has some difficulties.
She is not having spectacle. That's
Yes.
eye problem. Yes, no problem.
Paragraph 19, it says DW.
But then, will it not be the work of her junior to do it?
Yes, yes.
You are appearing for some other respondents.
Here is some problem also today. Rosba, I am.
19.
Because Mr. Singhon is already appearing for other respondents.
Yes.
Otherwise, we would have allowed.
DW in the cross examination would
Which paragraph you are reading?
19, 20, 21.
Paragraph 19 has 8 page 13.
8 no. 16, 15. Wait. is paragraph 13, Lordship.
Page 13.
Yes.
Paragraph 19, yes.
Do you object of framing of the issue to determine the
Material
points of dispute between the parties for the purpose of adjudication? Issues can be framed on a question of law or fact or mixed question of law and fact. This decision on the issue settle the lease in favor of either of the parties. A distinct issue is to be framed when the material proposition of law of fact is affirmed by one party and decided by the another. Also, there is no necessity to frame an issue. when the parties are on dispute on a particular fact or law. At the time of this, at times, despite pleadings, when a specific issue is not framed, but when both the parties on the list have let in accordance.
Yes, Mr. Demnath, we can permit Mr. Sinkon to help us, I think.
Just to, that is a.
She has some difficulty.
But I'll just start from the beginning, my lord.
You do not have to just, you can give this, because till now we have not come to the question of limitation anywhere.
Okay.
It is confined to the issue, object of framing issue and all. You see? Just read that part where the question of limitation comes.
Last part.
My lord, may kindly come to the last page, page number 16. Just before the paragraph number 24. It says, therefore, we are of the view that the High Court was not justified in remanding the matter to the trial court for fresh trial solely with respect to the issue of limitation, and that the court below have rightly held that the suit was barred by limitations, and the respondent number 1, 2, 3 are not entitled for any relief.
That is okay, but then it doesn't answer the query of the court.
My lord,
please take us to the part which at least gives up some idea.
Yes.
About the
where in a petition two orders passed on two different dates are challenged.
Different dates.
Then what should be
different dates? It is not regarding that. Should be merger.
No, we do not want merger right now. Forget about that. What happened on any other day.
Asking me about that, whether that two.
See, that had gone on the previous occasion. Today is one thing. See, like every passing remark doesn't become binding on you until and unless this is some other direction is passed on this.
Okay, we can. Okay, we can. Any order.
Okay.
Because I wanted to submit the order passed by the learned court below now, and 24. It is not merged with the order that is on 12/7.
That is all right. We can understand.
That is why we wanted to merger of the. That is the.
It's okay. We'll pass order. It's all right.
Yes, Lordship.
Your Lordship.
Yes.
Just 1 minute. I just clarify this matter. Whatsoever instruction I got, Your Lordship, that it may be helpful. Your Lordship, just I got whatsoever instruction does it matter. In the matter of this, there is earlier order 12/7/19. What's happened, Your Lordship? Just explain to this court. Whatsoever I got the instruction, Your Lordship, not in the records, in the judgment it is there. This I got this one. This the petitioner was filed the petition in order 6 Rule 15 CPC, and it was not earlier I tell that it was not signed by the affidavit was not signed by the.
Let us come to the impugn order. Just show us the review order passing the review on what ground it has been rejected. Do not go to the merits of the first order or the second order. Just say us. Let us see what is the ground.
Nine 12/2024, Your Lordship.
Where is that page?
This page 31 words is being. It is started from 27, but 30 is the.
Yes.
This is an application under section 114 CPC filed by the petitioner, applicant for review of the order dated 12/7/2019, passed in LA case number 1 of 2024, original case number LA number 117/2015. Next, this case was originally sent up for reference Deputy Commissioner Review District under section 30 of the LA Act 1 of 1894 to the Special Judicial Office Shillong, East Castle DC, in respect of the dispute between T.I. Shimle and Sri Ojendra Kharsanti in respect of the dispute having arisen in connection with the plot of land measuring 105 square meter located at Nongpo, Review District.
See, if it is noisy, you cannot hear anything. Yes. Please carry on.
105 square meter located at Nongpo, Review District, which has been acquired for construction of 4 lane from Jurabad to Omroi, including Omsniang bypass, Review District. The reference was received by this court on 17/8/2012. The reference was registered as reference LA case number 32B 2012. Notice was issued to the parties. As per the order dated 1/11/2013, Ojendra Kharsindi enters appearance through his counsel, Sri DMR Khail, OP Collector, appeared on 8/4/2013 by order dated 13/12/13. This matter was transferred to the Special Judicial Officer, Review District. The case was re-registered as LA case number 107/2015. Notice was reissued to the parties. The claimant entered appearance on 23/3/2015. On 2/12/2015, the opposite party filed claim petition. By order dated 14/3/2017, the then Special Judicial Officer, Review District, made the following observation. I perused the record. From the record, it is found that the instance case referred by the Collector, Review District, by reference letter number 1/8/2013. This reference was made under section 30 of the LA Act 1894, as there was a dispute between Srimati T.I. Simle and Sri Ojendra Kharsindi. After the matter was referred, notice was issued to the parties on 1/11/2013. Sri DMR Khail entered appearance foreign on behalf of the Ojendra Kharsindi. On perusal of the record, no Bokalatnama or Ojendra Kharsindi was found. On the contrary, Bokalatnama dated 1/11/2013 referred to the name of the Muntunas Kharsindi and the Juster Well Kharsindi.
Now, this where from Mr. Kharsindi comes, this reference was made because of the dispute between T.I. Simle and Ojendra Kharsindi, isn't it?
Yes.
So how come this Mr. Kharsindi comes here?
They came as a legal heirs. As a legal heirs.
Who?
This Muntunas Kharsindi and Juster Well.
Mr. Kharsindi is a legal heir of Ojendra. Ojendra Kharsindi.
Yes, he was expert. And
Because
this
Ojendra passed away by the time when the reference was made.
Before that.
So that reference was defective because this was made in the name of
Ojendra.
dead person.
Yes, it was. Yes, Your Lordship.
Now, could it be corrected by substitution application?
So, Your Lordship, this page
By
number,
the referee court, by the special judge. Was it not required that it should be corrected in the records of the collector? And the proper reference be sought for?
so page number 96, Your Lordship, this information was given.
Anyway, then
This court has
see this Ojendra Kharsindi was replaced by Mr. Kharsindi and Juster Kharsindi.
It is just pair was made on this.
Okay. Anyway, just continue. Just let us see.
This court has failed to comprehend as to how the Juster Kharsindi and Mr. Kharsindi has made a party in the instance case. There was no order either of implementing them nor substituting them as a party. The learned counsel representing Mr. Kharsindi and Juster Kharsindi fairly considered that Ojendra Kharsindi died. However, he could not produce any documents to show that Ojendra Kharsindi is no more. A claim petition was filed jointly by Mr. Kharsindi and Sri Juster Kharsindi. In para 4 of the claim petition, both the petitioner claims state they are inherited the land acquired by the opposed collector from their Manuel uncle Ojendra Kharsindi and their mother late Sensa Kharsindi. However, the petitioner are silent about the date of death of their uncle Ojendra Kharsindi and their mother Srimati Hansa Kharsindi. The learned counsel appearing for both the petitioner and claimant Sri Mr. Kharsindi and this Juster Kharsindi has informed this court that there is a suit pending before this district council court and the substitution of this learned counsel for BM Khark was recorded by order dated 26/2016 and the by order dated 15/10/2016. The learned counsel for both the petitioner shall file appropriate application informing about the status of the civil suit pending before this district council court, Shillong. The petitioner is given the liberty to file the appropriate applications to bring themselves on record in the instance reference. Needless to say, any application filed by the petitioner copy shall be served to the opposite. The learned counsel for Srimati T.M. Simle, Sri C.M. Odhikari has filed the claim petition which has been taken on record. The claim petition of the petitioner Mr. Kharsandi and Justice Kharsandi cannot be taken on record unless they are made party either by the substituent or the implementment. By petition number 62.
So that is where it has been recorded either by substitution or implement. So you have gone by this observation of the court.
Yes, sir.
Yes.
By petition number 16/2015 dated 23/2017, the petitioner herein, Mr. Kharsandi and Justice Kharsandi have filed application for implement and public substitution of the name of the petitioner in place of late Ojendra Kharsandi. On 3/7/2007, counsel for the claimant clarified that the by letter dated 19/12/2018, the collector was informed that Ojendra Kharsandi expired.
So if Ojendra Kharsandi expired on 9/12/2028,
9/12 it has been informed.
yes, then how come reference 9/12/2008? And how could this reference be made in 2013 in the same name of the dead person? On 9/12/2028, you have informed the collector that Ojendra Kharsandi passed away. And this reference is made in 1/8/2013 in the name of Ojendra Kharsandi.
Yes, yes.
Then? Go ahead, carry on.
However, the reference letter dated 1/8/2012, it is appeared that reference letter was made on under section 30 of the LA Act 1984, as there was a dispute between the Srimati T.I. Simle and Sri Ojendra Kharsandi. The binding order dated 12/7/2018, the application for substitution was rejected. The order is reproduced. The learned counsel for the applicant submit that the present application for substitution arises due to the demise of this late Ojendra Kharsandi, and the present petitioner applications before this court have inherited the said Switzerland from late Ojendra Kharsandi. Further, the learned counsel for the petitioner submit that the title suit bearing success has been duly decided in favor of the applicant petitioner by judgment and order dated 2/2017, passed by the learned proceeding officer Srimati S.B. Laitma, Subordinate District Council Court, Shillong. Learned GP assents to the present substitution petition since no provision has been made quoted by the applicant petitioner in the application for substitution. Even in the affidavit in page 4, only one of the applicant petitioner, Sri Justice Kharsandi, has shown this affidavit, whereas the co-applicant petitioner has nowhere endorsed the said affidavit. Further, the signature of the applicant petitioner need to be clarified. Having regard both the parties, reverse counsel, this court says make the following observation. The court is unaware if it has any jurisdiction to entertain or hear the present substitution petition, inasmuch as no provision of law has been exerted by the petitioner application, and invoke the power of this court. Without going into the...
Come to paragraph 5. Come, skip this part, just come to paragraph 5 now. On 13, next.
On 13/2020, the petitioner have filed this application under section 14 for review of the order 12/7/2019, raising the following contention.
12/7. So it was filed after 12/7/2019 and 13/2020. Yes. 5.
This matter came up
almost 7 months, isn't it? It was filed after 7 months. The review application was filed after 7 months of the order passed on the substitution application. Is it correct?
The matter was came up for hearing on 12/7/2019. The counsel for the collector review district made the oral submission that the subsequent petition without mentioning the section of law and the co-application petitioner was nowhere endorsed the affidavit. The learned counsel insisted on the written submissions by the counsel and against this reply by the applicant appeared on the submission made by the counsel for the collector, review district. That the matter came up again on hearing on 3/12 before the special judicial review district. During the hearing, it was learned that previous presiding officer of
You
the
can
court
skip
has-
this, come to the next thing.
So you will see here in this paragraph B, it is there when this petitioner got the knowledge of this order 12/7/2019. So it was subsequently come to know, and then it was after about and on the date of
But the
3/12/2019.
12/7/2019 shows that your presence was there.
So you will see it was
Anyway,
not.
we are not going into that question. But that was for the
So
trial court to do.
It is even this I am coming to paragraph B. That petitioner come again for hearing on 3/12/2019 before the special judicial officer's review district. During the hearing, it is learned. So the order of 12/7/2019, it was learned this order was passed rejecting this on 3/12/2019. And immediately after you receive this, they have applied for certificate copy and filed the review petition.
The fact remains that no separate application seeking condonation of delay was made.
Yes, yes.
Anyway, that's all right then. Then what happened? Come from paragraph 6 onwards. Read. Come to page 36.
The learned counsel for the private respondent submit that the review application is barred on 2 counts, that the application was not filed in the proper form, and that the application is barred by limitation, and there is no application for condonation delay, and learned counsel relied upon this
Decision such and such.
Then learned counsel for the collector entered the submission made by the learned counsel for the private respondent. The applicants came up for transfer with this court from the Court of Special Judicial Review District, Nagpur, by order dated 6/7/2024, passed by the Honorable Chief Justice, High Court, Meghalaya, in connection with the transfer petition number such and such. During the course of hearing, learned counsel prayed that he may be allowed to withdraw this application with the liberty to file fresh. However, no application was made in this petition. Section 114.
What is that? During the course of hearing, learned counsel means the petitioner, review application, the review petitioner. Prayed them to be allowed to withdraw this application with liberty to file afresh. However, no such application was filed by the review petitioner. Means what? No such application seeking withdrawal was filed. Does it mean that?
Yes, yes.
No. Then read paragraph.
Section 114.
Skip that paragraph 10.
Section 114. This.
Read paragraph 7. This quotes this thing. It is 114 is quoted there, so we may not go through this.
Okay. Then order
47.
47.
Yes, you can skip this also. This speaks about revision.
Then order 47 is mentioned, 41 is mentioned. Then order again 41A. Then Article 124 Limitation Act. Then the review has been filed after the delay of more than 6 months without application for conventional delay. The application for review filed by the petitioner at the very outset has not been filed in accordance with the provision of the Order 47 Rule 3 CPC, read with Section 41 Rule 1 and 3 CPC, and is also not accompanied by the application for conventional delay. Therefore, on this count alone, without going to the merit of this review petition,
All right.
the application. So, Your Lordship, in this matter, that when this knowledge and others come up, and then petition was filed under 114.
Okay, we'll see it with all the school passwords.
My respect to submission here, Your Lordship, I am on the matter of this 9/12/2024, and this petition is filed against this order. And in this matter, if it is considered this section 12(4) of this Limitation Act, then it is within the time.
Just say it again, please. Your thing is that
This, as per section 12(4) of the Limitation Act,
yes.
then my review applications
You have a
filed
limitation.
within the time.
What is meant by the word award here? 12(4), section 12(4).
You know, see, this, though it is not award, but it is the order pass and it is going to be finally disposed of. So this section, subsection 4 will come.
So this award will mean what?
It is saying there's a competent period limitation for application for set aside and award. So I am not award, but I am for the order. This time requisite for the obtaining the copy of the. So you see, when I am applying for copy of the order.
No, what is award? Just minute. You see, in the other preceding provisions, the award has not been mentioned anywhere.
Even we can come to the 12(3) also, which is wherein there's a decree or order.
So you are not sure whether it is 3 or 4.
You didn't say me.
That is the problem. When court asks you something, then you change yourself and then you cite different provision. All along your case was that your 12(4) will apply, now you say 12(3) will apply. So your contention is that time consumed for obtaining certified copy should be excluded.
Yes, yes.
So how long so you are covered under section 12(3), not 12(4). So then, when did you apply for certified copy?
10/12.
10/12 of?
10/12/24.
Okay, and how long it took?
It is, takes 72 days. About 72 days.
72 days for?
Obtaining the certificate.
Obtaining certificate copy?
Yes, yes.
Where is the certificate copy of that?
This is page 27. Date fixed for delivery of requisite number of stamp and folios, 19/2/2025.
Yes.
Page 27.
And then date on which the copy is 19/2/2025.
I have supplied on the same 9/2 and I got the certificate on the same day.
So how many days it took?
So I have given on the same day. I have given
that is okay. The date of application is 10/12/2024, isn't it?
Yes, yes.
Yes, so how many days it took? From 10/12? 19/2?
Yes.
2 months?
More than 2 months, yes.
Huh?
More than 2 months.
How many days? Okay, it's all right. Yes.
Lordship, my submission is that the condonation petition is more than 5 years, 9 months, 19 days.
And the period spent in the review application could not have been condoned.
Oh, that cannot.
That is not your.
That cannot.
No, no.
My lord, I'm praying for a week's time, my lord, to file my rejoinder to the affidavit, my lord, filed by the respondent number 8.
Yes, you have not filed till now.
We have not filed, my lord. The client, my lord, the petitioner is from Garo Hills, my lord.
Who is appearing for the respondent number 8?
Respondent number 8. On last occasion also she did not appear, Your Lordship.
They've not been appearing, my lord, for quite a big hosh, but they have not appeared
Is
for
a
the last
council,
3
local
days.
council?
Yes, she is a local council, my lord. But I feel, my lord, I have a
Yes.
feeling that
You have any objections? You are not respondent number 8, isn't it?
No, I represent only respondent number 1 to 6, Your Lordship.
Okay. Just say. Mr. Tapal, Honour Counsel, is present on behalf of the petitioner. Mr. Abraham, you are appearing for?
1 to 6, Your Lordship.
1 to 6 is present on behalf of the state respondent. Then who is respondent number 7?
7 KP Bhattacharya is appearing, Your Lordship.
None appears for the respondent number 7 and 8. Yes. Then this on prayer made by the learned counsel for the petitioner. How much time you need?
a week's time will suffice, my lord. Let it be after 2 weeks, my lord, to be on the safer side.
But the 2 weeks time is granted for filing a rejoinder to the affidavit of opposition filed by the respondent number 8. List accordingly.
Hello, Bless, Your Lordship.
42.
Application for recalling of witness, Lordship, where the trial court has allowed it, we're challenging that.
Yes. Yes. What is your prayer here?
Just 2 weeks' time may be granted, Lordship, for further hearing.
44 just on prayer made on behalf of the petitioner. List after 2 weeks.
2 weeks, Lordship.
Yes. Yes, Mr. Nath, do you have anything? Yes. Who is the other side?
I'm here, man.
And
No
from
objection.
43 on prayer made by Mr. Ishanath, appearing for the appellant. Not objected to by Mr. Gurung Ranad GA. Appearing for the respondents. List is met after 2 weeks.
Deeply appreciated.
So only this appeal will be there in the second half. There is no other matter. Yes.
42.
My lord, the conducting counsel will be appearing through video conferencing.
Yes.